So I'm excited to start off day 3 with this 6th annual review with our session 8 on claims, disputes, and terminations. Our panel members include Judge Gary Summers, who is the Chief Judge and Chair of the U.S. Civilian Board of Contract Appeals, Robert Nichols, who is the founding partner in Nichols Lew, Paul Corey, co-chair of Wiley's Government Contracts Practice, Seth Locke, co-chair of Perkins Coie's Government Contracts Practice, and finally, last but certainly not least, Dan Graham. Dan is vice chair of Vincent and Elkins Government Contracts Practice Group. Paul, may I turn it over to you to get us started?
Absolutely, and thank you so much, Alan. Really looking forward to this session on claims, disputes, and terminations, and we've got a great panel to do it with. Just to give you an overview and what we're going to try to do here, we picked out some of the most interesting cases of the year and decided to put them into different categories. And each of us will probably be addressing some cases in each category. So we're going to start out with constructive changes and terminations. Then we're going to, and one of the interesting things that you'll see as we go through here is Federal Circuit has actually issued a number of decisions that are valuable for contractors and in a number of these areas. So we'll start out with constructive changes and terminations. Then we get to another area that contractors deal with government claims and investigations. There's always jurisdictional issues, and so that's going to be next. Elements of entitlement. So we talk about some of the merits of different decisions, and then timeliness and waiver. There's still ways to mess things up, and we want to see that we can avoid doing that in the future. So let's get to the first topic, constructive changes and terminations. So we have 7 different cases here that we're going to be talking about. And as I mentioned, the Federal Circuit has chimed in with some very helpful case law. And the first case, which Robert is going to discuss, the Kiewit Infrastructure versus United States case, is one that I know I'm going to certainly cite when it comes to interpretation of a contract. It was a very helpful decision. So Robert, why don't you start us off with that one?
Thanks, Paul. Good afternoon, everybody. Paul's right. This Kiewit case is a very good case for contractors. The Federal Circuit reversed a Court of Federal Claims decision denying a contractor's claim. The dispute involved a contract for road construction in Alaska awarded by the Federal Highway Administration. The solicitation required the awardee to dispose of waste from the road construction, essentially dirt and gravel, that was generated during the road construction at sites listed in a report called Waste Disposal Site Investigation Report. The solicitation stated that the sites listed in the report had received clearance under NEPA, the National Environmental Policy Act, and that, quote, no further analysis of environmental impacts of using these sites is needed. And that's a very important issue here. It cites NEPA, but then goes on to say no further analysis of environmental impacts is needed. The FHA also provided offers with a categorical exclusion, a document that the agency prepared in accordance with NEPA to weigh the environmental impact of government action. And this categorical exclusion referred to the sites listed in the waste report and reiterated language from the solicitation saying no further environmental impacts are needed for using these sites for material waste. Well, after it began performance, Kiewit found that several of the government's waste disposal sites were on wetlands, and that to use those locations, Kiewit needed to purchase wetland mitigation credits. They did so, and they requested a request for equitable adjustment for the cost of purchasing these credits, claiming they had not expected to have to purchase these credits for mitigating the wetlands on the waste sites, so it was a compensable change. The contracting officer denied this, and the Court of Federal Claims agreed with the contracting officer. They both found that Kiewit should have understood from the solicitation that they would need to look at other things other than NEPA, for example, the Clean Water Act, to determine what additional environmental impacts there could be. On appeal, Kiewit argued that the solicitation affirmatively represented that no further environmental analysis was required, and that they had not caveated that by saying no further environmental analysis only under NEPA. So the company had reasonably concluded that it didn't need to perform any other environmental analysis whatsoever under NEPA or under the Clean Water Act. So this was the heart of the dispute. The government said, but we kept saying NEPA, and so that's all that we were guaranteeing. And the contractor saying, but then use this vague open-ended language that no further environmental assessment was needed. Well, the long and short is that the Federal Circuit said contract language matters, and the solicitation did not state that no further analysis would be necessary for only NEPA purposes. Instead, it broadly stated no further analysis was necessary for the environmental impacts of using these sites. If the government had intended to exclude wetland impacts from environmental impacts, it should have used language to that effect. So this is a very good contract interpretation case for contractors. And it goes to show how continuing to press these claims for interpretation up to the Federal Circuit when necessary can be beneficial. Paul?
Yeah, I agree with that. And I'm going to be citing this case for any contract interpretation issues going forward. It also cites other good Federal Circuit cases, Precision Pine and States Roofing, that are favorable to contractors and basically say you got to read the language. The language means what it says. So a good case for contractors. Now, the next case that Robert is going to talk about, the Pernix Circa case, if we can move to that, is not a good case for contractors. So this is something that we see periodically with contracting officers going out of their way not to be helpful, in my view. And this is one of them. You want to talk about this one, Robert?
Yeah, this case I think was frustrating for a lot of companies and government contracts lawyers because, to your point, the contracting officer didn't actually do anything to be helpful here, in my opinion. In this case, Pernix Circa joint venture had a firm fixed price contract with the State Department to construct a rainwater capture and storage system in Sierra Leone. And the contract provision regarding excusable delays said that Pernix would be allowed time, but not money for excusable delays. And the contract defined excusable delays as, among other things, acts of God, epidemics, quarantine restrictions. Well, in 2014, while Pernix was working on the system, an Ebola virus broke out in Africa and spread to Sierra Leone. Pernix, concerned about the safety of its personnel, asked the State Department for guidance on how to proceed, but the agency declined to provide any guidance whatsoever. After the World Health Organization declared the Ebola outbreak an international health emergency, Pernix unilaterally decided to shut down the project and evacuate the work site to protect its people. Over the next few months, Pernix met with the State Department representatives to discuss the ongoing crisis. Each time, the State Department told Pernix that the company was on its own and that the agency would not provide any additional guidance on whether Pernix should restart the program. In March 2015, after it had been off the job for several months, Pernix returned to the work site, and for the safety of its personnel, they expanded its medical facilities on the site and hired licensed paramedic. A few months later, Pernix submitted a request for equitable adjustment to the State Department for the costs associated with the additional medical facilities and for delays and additional work that Pernix had to perform as a result of the epidemic. And the State Department either denied or took no action on the REAs, leading Pernix to submit a certified claim for these Ebola-related costs. The State Department denied the claim, and Pernix appealed to the civilian board. The board found that the agency was entitled to summary judgment. Pernix had a firm fixed price contract with the State Department, and the contractor assumes the risk of unexpected costs not attributable to the government under the express terms of the contract. Since it was a firm fixed price contract, all Pernix was allowed to receive was the price and unpriced cost extensions. And that was specifically laid out in the contract. So the civilian board was really bound by the contract terms and the agency's refusal to provide any input here. And so as a result, Pernix was required to suffer all of the costs related to its contract performance. And the key factor here was the silence from the government. If they had said, we need you to keep working, perhaps there could have been a constructive acceleration claim. If they had said, we want you to build this extra hospital, perhaps there had been a constructive change in the scope of work. But by not weighing in, Pernix really had a couple of options: either stand down entirely and just get delay days, but not costs, or to take the risk of proceeding. I think this is important in the context of the pandemic. And in fact, when this came up, this case was decided, I believe, in March or April of this year, right after the pandemic from COVID hit, and contractors were trying to figure out what exactly should we be doing here? Should we be continuing to work? Should we be putting in extra mitigation efforts to be able to work, et cetera? And what I think that this case shows us is that even in the context of COVID, where OMB and agencies have weighed in with guidance to contractors, I think you're likely to see claims for COVID-related costs, and you're going to see denials based on Pernix, and we'll see how those play out. Paul?
Yeah, thank you, Robert. I think you're exactly right on that. Although the difference, I think, is although initially we were seeing a lot of contracting officers basically taking the same approach. Oh, there's a COVID problem. Well, let's hope that works out. Let me know what you do. Stay safe, which is essentially what this CO did. But pretty quickly, once you had Section 3610 of the CARES Act and guidance from agencies that contracting officers needed to engage with contractors, we did have much better engagement than that. So hopefully this is an outlier, but we'll see. Now moving on, and by the way, this case is up on appeal, so we'll more to come on that. Moving on to a case where a constructive change was found because there was an order from the agency, is the Raytheon case, and Chief Judge Summers is going to talk to us about that one.
I will, with the caveat that I am speaking for myself, not for the CBCA or for the United States government or for anybody who's not me. So with that, so in Raytheon, the contract clauses at issue concerned a statement of content, which is like a statement of work governing the production of AMR, AAM, air-to-air missiles. One of the clauses required Raytheon to manufacture, test, and integrate and deliver a number of missiles over a 3-year period, and included all the activities necessary to produce those missiles. However, another clause required Raytheon to support future missile production as a sustainment of fielded missiles over a 1-year period. Since 1997, the system engineering program management support work identified in the second clause involved both the sustainment of missiles manufactured under previous contracts and the production of new missiles under Section 2A. So in 2013, the contracting officer interpreted the contract requirements differently than in the past, concluding that the contract required Raytheon to provide 3 years of maintenance support, discounting the clause limiting the support to 1 year. As a result, the contracting officer directed Raytheon to continue performing the production support work even after the conclusion of the 1-year period of work under Section 2B. Of course, Raytheon appealed this order and filed a claim. the Armed Services Board of Contract Appeals found that contract clauses setting forth how long Raytheon was required to provide production work was ambiguous. In order to resolve the ambiguity, the Armed Services Board turned to a large body of evidence regarding the parties' course of conduct, course of dealing to determine whether the two sections governed the production maintenance contract. After assessing testimony from many people, government officials and others, and evidence of past contract negotiations, the Armed Services Board concluded that both Raytheon and the Air Force had a common basis of understanding that the clause SOC2B covered production EPM. Based on this common understanding, the Armed Services Board held that the contracting officer's demand for 3 years of production support constituted a constructive change entitling Raytheon to its requested equitable adjustment. What's unusual to me here about this analysis is that the Armed Services Board did not follow the traditional analysis of looking to see whether the ambiguity was patent or latent, nor did the board examine whether Raytheon had a responsibility to clarify the ambiguity before bidding on the contract. Rather, the decision, really in dicta, observed that evidence of a course of dealing may establish an enforceable contract even absent an ambiguity. If, as the Armed Services Board noted, a course of dealing involves the same parties and essentially the same contract provision, it may evidence waiver even explicit contract languages. So I note that legal commentators, okay, mostly it's Nichols and Liu, suggest that the juxtaposition of such strong course of conduct evidence with superfluous paragraph about the power of course of performance evidence to override the text of the contract may signal that the Armed Services Board considered the contracting officer's purely textual position to be reasonable. I'm not really sure I read the opinion to be that earth-shattering. The failure to examine the ambiguity argument and instead jumping immediately to course of conduct is problematic in my mind, but that's just my opinion.
So Judge Summers, I mean, if you were to look at whether or not you would think that ambiguity was patent or latent, I mean, it struck me anyway, since it did say it's 1 year, that it may be more likely to be latent than patent if one did that analysis.
I agree with you. I was disturbed by the lack of analysis on those points. I think, you have to at least go through the steps and address whether it's patent and latent before you jump to a course of dealing or conduct. I kind of like the structure because otherwise you're left with not knowing for sure whether or not these other statements in the decision are dicta. And if they're dicta, how do they help a contractor later on trying to analyze the decision and apply it to their own cases?
Makes sense. Makes sense. All right. So the next case on our list, ACLR, Robert's going to handle this, and this is kind of an interesting one where a contractor alleges breach, but there's a finding of constructive termination, which is not something we see every day. Robert, want to tell us about that?
It isn't something we see every day, but this case was actually very timely because we have another constructive termination case going on. Pupke's writer rightly, I think, called this one person's breach is another's constructive termination for convenience. Here, ACLR received a task order from the Centers for Medicaid and Medicare Services, CMS, to provide financial management and audit services under a GSA schedule contract. ACLR commenced several audits and sought payment. However, CMS found problems with the audit. Specifically, according to CMS, ACLR had not identified the records it had audited, hadn't implemented a framework for collecting the overpayments that it identified, and CMS had concerns with the data generated by the audit. Notably, CMS didn't formally terminate the work, but rather merely told ACLR to stand down from further work. Well, ACLR submitted claims to CMS seeking fees for the work that it had performed, and also claiming that by being told to stand down, they were losing a lot of the work that they should have been able to do and losing the opportunity to earn bonuses. CMS denied the claims, leading ACLR to file suit in the Court of Federal Claims, alleging that CMS had breached the audit contract by canceling the audits. The court found that CMS's actions could be deemed a constructive termination for convenience. as Paul noted, you don't find anything about constructive termination for convenience in statute or regulations. It's a judicially created concept to retroactively justify a breach by the government when the basis on which the contract was terminated is legally inadequate to justify the actions taken. So here, the court said, CMS expressed their views that the audits were problematic in some way. They weren't working. And that was a sufficient change in the circumstances to warrant a constructive termination. So we're going to call this a constructive termination due to the change in circumstances. So in one respect, this was positive for the government in avoiding breach damages. On the other side of it, the contractor was still able, under the termination for convenience clause, to recover the cost for the work that it had actually performed. And so I think this case is interesting. Like I said, we're seeing this in another case where the government essentially wanted to stop performance, didn't want to default terminate, didn't want to convenience terminate and open themselves up, and just simply said, we are canceling the contract. And essentially it is a constructive termination. And so I don't think this is going to come up very often, but when it does, ACLR provides a good case for citing.
Right. Yeah, thanks. Yeah, so that at least the contractor has some potential remedy there. So
Right.
the next case on our list, Valerie Lewis Janitorial, we've talked a little bit, Pernix was a case like this. We've talked a little bit about the COVID cases. Here's another one involving bacterial infection that leads to a constructive change. And Seth is going to walk us through this one.
Yes, and thanks, Paul. This is interesting because here, we're dealing with COVID and an outbreak and the pandemic, and this one had an outbreak of a bacterial infection, which did, like Paul said, lead to a constructive change. So we'll see if that's useful for contractors where in response to the pandemic, they have to go through additional work. The way the board got here, though, has some lessons for contractors. So what happened here was there was a solicitation that went out for janitorial services by Veterans Affairs, and it was to provide cleaning services for hospitals in California. And there was a lot of confusion early on in the contract, once it was awarded to Valerie Lewis, about how often and the frequency in which the beds and everything needed to be cleaned, and the facilities, which facilities needed to be cleaned. And if you read the opinion, there's a lot of back and forth between the contractor and the government about that, and about what the real statement of work was. And interestingly, they kept going forward with performance, notwithstanding this, very clear, and I say clear, but clear confusion about what the work actually was that was supposed to be performed. But in any case, they kept going, and eventually there was this bacterial outbreak. It was a C. diff, and it was a bacterial infection that was really dangerous and spread very easily, very contagious. And there was direction from the nurses and the doctors that were in charge of overseeing this infection to the cleaning staff to go ahead and use a, quote, two-step cleaning process. And that meant, a lot of extra work. They had to use a diluted, bleach cleaning supplies, and they had to actually clean it, wait, and then clean it again. And as a result of that, Valerie Lewis went to the contracting officer and said, this is really not what we anticipated. It's definitely a change from the scope of work. So we would like to modify the contract. Well, what's interesting here is Veterans Affairs personnel, the contracting folks, they actually did what they called a time study analysis. They went and they interviewed people, they talked to people, and they found out that sure enough, it was taking extra minutes to clean each room. And then they calculated those extra minutes into how many hours per day, how many hours per week. And they actually came up with an increase in the number of FTEs and full-time equivalents that had to actually be assigned and hired to do this extra work. And they then quantified it, and they quantified it at $180 million, or sorry, $180,000. And at that point, they notified Valerie Lewis, yeah, there's going to be these costs. And the two parties entered into a bilateral modification to the contract. And at that point, also, Valerie Lewis had submitted a certified claim for all these extra cleaning, this two-step cost associated with the extra two-step cleaning. And when they entered into the bilateral modification, it expressly said that we're adding to this contract this two-step cleaning process. Now, to me, I would look at that and I would argue that's very clear evidence that if you're adding a two-step process to the contract, there was no two-step process in the contract before that. Well, the modification went on to say that we'll address the actual costs associated with the two-step cleaning process in the resolution of the certified claim. At that point, when I read this, I'm shocked, but the COFD that the contracting officer issued actually denied the claim, and it said that the contracting officer had done her own investigation and talked to people and found that this two-step process actually didn't involve any additional time, any additional cleaning time. Now, that was entirely inconsistent with the other folks at VA who had done this time study analysis and found that it increased the costs. And the board found that incredibly important. The board noted that a final decision that just has unidentified people saying that this wasn't a change and no evidence that rebuts the VA's own time study analysis saying that this was in fact extra work is not going to be considered. And the board rejected it, and rightly so. And as a result of that, the board was then going to decide quantum. And interestingly here, I thought the board ended up relying on the jury verdict test. And what it said is we have to rely on the best evidence available. The board was clear, we don't think Valerie Lewis supported its costs. But I think that, when you look at these facts and everything that happened, it was so clear that what VA did here was wrong that the board ended up deciding to use the jury verdict test. And it went back to the VA's own time study analysis and said, here, you thought it was $180,000. We're going to go ahead and award that to the contractor. So a couple lessons learned here. Yes, there could be a constructive change, but it is so important to track those costs as it's happening and to really pay attention to that, because I think that the contractor here got lucky that the facts were so egregious that the board was willing to rely on the jury verdict test, when in a lot of other circumstances, as we've seen, the board's not willing to do that and wants to see actual costs for the change. So we'll see if this is something that plays out with the pandemic. But again, word to caution, make sure you track your costs if you do think there's a constructive change.
Thanks, Seth. Very, very thorough. I was amused when I was reading this because it was just so like COVID that the second step involved applying bleach and letting it sit there for 10 minutes before wiping it off. The other thing is I was very heartened by the language on quantum, which is again some language we're certainly going to be using. Contractors will certainly use in the future when they can't prove up their costs. We have a case that I think Judge Summers will be talking about a little bit later involving Raytheon, where they couldn't prove up their costs, and the jury verdict was given sort of the back of the hand. So that's a useful one for contractors. The next case, which Dan Graham is going to talk to us about, BGT, involves a situation where the government initially was going to provide GFE and then did not. And so anyway, this is also a good Federal Circuit case for contractors. So Dan, you want to walk us through it?
Sure, happy to. So this is a great example of one of those cases that you see in the Pub K Law Digest in the morning, and you read what the holding is, and you ask yourself, did we really need a case that said that? Didn't we already know that? Didn't we already know that the phrase "shall consider an equitable adjustment" gives a contractor an affirmative right to an equitable adjustment that can then be appealed under the CDA? Well, apparently we needed a Federal Circuit decision to tell us this one, and it's an important point that had not been addressed in a prior decision. So BGT involved a contractor that had sued the government, asserting a host of claims, and some of the confusion may have come from the fact that the contractor was asserting claims for, in addition to the claims for an equitable adjustment under the government property clause, they were asserting claims for breach of contract, breach of the duty of good faith and fair dealing. There was a lot of emotion wound up in this litigation, but it was all based on the government's decision to withhold certain government furnished equipment, and as a result, the contractor had to go out and buy that withheld equipment on the commercial market, and the contractor tried to recover the cost that it incurred to purchase the equipment that the government had said it would provide. The government argued at the Court of Federal Claims that the contractor's claim under subsection D2I of the Government Property Clause 52-245-1 couldn't be maintained because the contracting officer was required only to consider BGT's request for an equitable adjustment, not to grant the adjustment. No comment. The panel rejected that argument because, quote, the phrase "shall consider" gave the contracting officer, the government rejected the panel rejected the government's argument that the phrase "shall consider" gave the contracting officer discretion to grant or deny an equitable adjustment and imposed no duty to grant an adjustment, even if BGT could prove financial loss due to the government's withdrawal of the GFE. According to the panel, the government's interpretation would produce absurd results if the Navy's only obligation would be merely to think over the request before denying it. The panel said in its opinion, it is dubious to say the least that the drafters of the FAR's Government Property Clause envisioned that the government would essentially have an unfettered right to withdraw a promised GFE from a contract without consequence. According to the court, "shall consider" in this contract setting doesn't give the government absolute discretion, but instead holds the government to a duty of good faith and reasonableness. More importantly, because the CDA provides for appeals and de novo review, that gives the contractor the right to take its claim if the government exercises that obligation and denies the claim, take that claim to the board or the court. The Federal Circuit remanded the case to the court to determine whether BGT was entitled to an equitable adjustment as fair compensation for the failure to deliver the GFE.
Thanks, Dan. Oh, go ahead.
And well, I've got the next one. So
wait, I just wanted to point out before you get to that.
Sure.
The DOJ argument really was, well, we have to consider it. No. We've met our burden, and the court just wasn't having that. And the case that Dan's about to talk about next is an example of what I would call, which is the Vet for You case, an example of the government behaving badly. And I'm sure you can go ahead.
We can say on this slide one last point about BGT, though. So the Government Property Clause does say "shall consider." Other clauses, including the changes clause, says "shall make." So can you blame somebody for having the idea that there's a difference between consider and make, and that difference should be given some meaning? I don't know, but we have the decision now. The decision is no, there's no difference. Shall consider is an entitlement to an equitable adjustment if you can demonstrate that the facts warrant it. So moving on to Vet for You. This is a CBCA case. It's an EJA case, Equal Access to Justice Act case involving attorney's fees. The contractor here had appealed 23 different claims totaling about $300,000. The contractor only prevailed on a handful of claims, and the recovery was $46,000. So not some success, not a tremendous amount of success, but the contractor was a small business, filed a claim for attorney's fees under EJA, and the board awarded those attorney's fees. This contract was a contract to transform the crawl space under a VA hospital into a functioning floor of that hospital. The basis for the award was the agency's failure to act when the circumstances required it. As Vet for You's costs mounted for issues that the government was responsible for, the CO sent stern emails, sometimes bordering on verbally abusive, from off the site, but never visited the project site and did not attend project meetings. The board here rejected the agency's argument that its position was reasonable simply because it prevailed on the majority of the claims or on particular issues or arguments. Instead, the board looked not just to the agency's legal position and arguments during the litigation, but also to the agency's conduct during performance of the contract. A great couple of quotes here from the opinion. The VA's failure to recognize its own hand in increasing the cost of performance prevented the parties from resolving disputes in a more cost-efficient manner. And there's a litany of things that the government did here, forcing the contractor to bear the cost of renting a crane to move a shed and dumpster because the VA didn't have enough money in its budget to move it itself, failing to promptly address a burst water pipe and then refusing that the contractor wasn't responsible for, and then refusing to reimburse the contractor for the emergency repair, ignoring the contractor's request for assistance and getting cooperation from an adjacent contractor who was impeding Vet for You's work on the excavation part of the contract, and then leaving Vet for You in limbo for weeks on a costly change order, and trying to explain that by saying that they were understaffed and had their own personnel and budgeting issues. Bottom line, in an attorney's fees application under EJA, the board, the court will look to the totality of the dispute, including the government's conduct during this dispute, not just the government's conduct during the litigation.
Thanks, Dan. Hey, Alan, I note that we have a couple of questions on this category, and we're about to move on to a different one. Should we address those now, or how do you want to ask to go?
Well, why don't you go ahead and take them now? They're relevant, and but I'm just mindful of the time to make sure we get everything done. So
okay, we'll try.
Short answer.
We'll do it quickly. So, any chance that Biden's Defense Production Act invocation as a war opens the door for Pernix type claims for COVID to be compensable? I mean, my short answer would be I would certainly make that argument. Robert, I don't know your thoughts.
Yeah, I think that's right. You know, I think we've made that same argument with regard to, for example, OMB's guidance to agencies telling them to be creative and supportive of contractors in doing workarounds. And so I think that you can look at these sort of extra contractual government actions that have a contractual impact and claim constructive change and the like.
And then the other one actually probably would be for you too. On ACLR, do you think the constructive termination was a way for the court to prevent the contractor from being unjustly enriched?
You know, it's hard to put my mind or put myself in their shoes. I wouldn't be surprised. We've seen a number of cases, and we'll talk about one later on, a KBR case, where, in my opinion, the judges exercise discretion in interpreting circumstances in a way that perhaps reached the right equitable result. And so I wouldn't be surprised if that was a consideration here, especially considering the nature of the problems with the audits that CMS occurred and the fact that CMS had not default terminated, they had gone this route instead.
Okay. All right, thanks. So we're going to be moving on, next slide, to a separate category, government claims and investigations. We've got 3 cases in that category, including a couple of appellate court cases, Federal Circuit and Fourth Circuit, which I'll be talking about, and then the Supreme case, which is it was a wily case and quite a handful, and Dan's going to try to unpack it for us. So let's get started with agility. Next slide. So this is, as I was mentioning, is another good Federal Circuit case for contractors. Contractors will often face a situation where the government has claims against them, where the government will seek to will demand payment and then will seek to offset from other contracts whatever amounts that they have announced are due under the Debt Collection Act, and so that was what was at issue here. Agility had challenged at the Federal Circuit a Court of Federal Claims decision relating to the offset of monies that were due to Agility. The Court of Federal Claims had determined, well, the offset was valid and granted favor granted judgment in favor of the United States. Federal Circuit vacated that and remanded it because the Court of Federal Claims didn't really evaluate the merits of the United States offset determination under the Debt Collection Act, and also didn't consider whether the agency had properly followed all the procedures and provided all of the safeguards to the contractor that it should have. So this case involved alleged overpayments by the Coalition Provisional Authority, the CPA, on an Iraq reconstruction contract. So there was no privity actually between the United States and Agility, between the Army and Agility. The Army was providing assistance to the CPA, and then the CPA had all of its authority transferred over to the interim Iraqi Government Council. So anyway, following a DCA audit, the Army contracting officer issued final decisions regarding various task orders under which the Army had paid Agility with U.S. funds, but on behalf of Iraq, and found that there were a number of overpayments totaling $80 million, primarily relating to not being able to sufficiently support subcontractor costs. And so they sent letters to Agility saying that Agility was, quote, indebted to the United States government for the overpayments. And each letter said, hey, if you want to contact the CO for more details, please do. And warning, hey, this debt could be subject to offset from federal payments due. So Agility initially appealed these decisions to the ASBCA, these alleged overpayments. And the ASBCA said, well, we don't have jurisdiction. U.S. isn't a party. And that was actually confirmed by the Federal Circuit on appeal. But separately, the Army notified Agility it would withhold $17 million on another contract. And so Agility went to the Court of Federal Claims this time, challenging the offsets. Now, the Court of Federal Claims on a 12C motion for judgment determined that the U.S. was owed the monies, and the Collection Act authorized the collection. The Federal Circuit vacated, and it said, first, the DCA doesn't give the United States a freestanding mechanism to create a debt, but rather provides only a mechanism to offset a pre-existing valid debt. And under the DCA, a claim means any amount of funds or property that has been determined by an appropriate official of the federal government to be owed to the United States. And so in order to be recoverable, it first has to be owed, and you can't reasonably interpret that to shield the question of whether a debt is owed from judicial review. So when a court reviews a challenge to a DCA offset, it stands to reason the review has to encompass whether the United States was really owed the debt. And so they found that the court below failed to even consider that issue. And they also found that the court hadn't considered all of the safeguards in the DCA that contractors are entitled to, which weren't necessarily given to Agility here. One was written notice of the type and amount of claim, the opportunity to inspect and copy records, opportunity to review within the agency, the decision, and so forth. So again, a good case for contractors that the government can't simply start offsetting your other contracts and then avoid judicial review for that. Next case that we're going to talk about, the Floor case, is also a good appellate court case. It's a Fourth Circuit case, a little bit different from what we're used to, and it deals with the question of when a contractor provides a mandatory disclosure to the government, whether that mandatory disclosure constitutes a waiver of attorney-client or work product privilege relating to any internal investigation that the contractor engaged in. So Floor had a building project in Afghanistan. At a certain point, it began an internal investigation of an alleged conflict of interest involving one of its employees and a potential Floor subcontractor. Following the investigation, it terminated the employee and it sent its summary of its findings to the government pursuant to the mandatory disclosure rule. And basically, here's what the summary said. One, the employee had a financial interest in and appears to have inappropriately assisted a subcontractor, a Floor subcontractor. Two, Floor considers this a violation of its conflict of interest policy and code of business conduct and ethics. Three, the employee used his position as the Afghanistan project manager to pursue his own business interests. Four, Floor estimates that the government may have been financially impacted by this because the employee was charging to the contract task order question. So separate and apart from that, the employee sues Floor in district court in a retaliation and employment claim, and seeks all the files relating to the internal investigation, saying, hey, those were waived when the mandatory disclosure was provided to the government. Now, initially, a magistrate judge denied the motion, agreeing with Floor, but then the district court overruled the magistrate's order. And the district court concluded that those four statements revealed, quote, legal conclusions which characterize the employee's conduct in a way that reveals attorney-client communications. So they say you waived the attorney-client privilege as well as the work product privilege. So Floor challenged that, and the Federal Circuit basically agreed with Floor. What they said was, to find a waiver, you have to find that there's been a disclosure of communication or information, not just there's been a disclosure of communication or information. To find a waiver, a court must find that there has been a disclosure of communication or information covered by the attorney-client privilege or work product protection, but we will not infer a waiver merely because a party's disclosure covers the same topic on which it had sought legal advice. So what they were saying is, just because the Floor got legal counsel and came to those conclusions, those bare conclusions are not the communications that they had with government and do not constitute work product in and of themselves. So you have to do more. And they cited an example of another case where they had found that there was no waiver, where an appellant was initially argued to have waived the attorney-client privilege by answering no to a question on a publicly filed document based on the advice of his attorney. And the answer was, you can say no, you can get that advice, but you're not revealing what the attorneys told you or any work product by just providing the conclusion. So they went on to say there is no evidence to suggest that the four statements in Fluor's disclosure quoted privileged communications or summarized them in substance and format. Rather, the statements do no more than describe Fluor's general conclusions about the propriety of their employees' conduct. So a helpful case to avoid the waiver of privilege. With that, I'll turn it over to Dan to talk about the Supreme case.
Thank you. And as you said earlier, that this one is quite a bit to unpack. So this case involved multiple appeals arising out of a contract for the delivery of food to U.S. forces in Afghanistan. The contract originally required Supreme, the contractor, to deliver food to 4 large military bases. But very shortly after executing the contract, DLA issued a modification that directed Supreme, excuse me, to begin delivering food to a number of smaller forward operating bases, FOBs. The parties spent several months negotiating a price for these FOB deliveries, and Supreme proposed a series of rates per pound of food delivered. DLA provisionally accepted Supreme's proposed rates, and the parties executed a modification stating that the proposed rates were acceptable for purposes of an equitable adjustment until verification of the rates was completed. Performance ensued, and DCAA conducted an audit of the rates and Supreme's costs under the contract. Supreme objected to the scope of the audit, arguing that it was a commercial item type contract and that a lot of the information DCAA was requesting was inappropriate. DCAA concluded, based on its audit, that the provisional rate that had been negotiated for these FOB deliveries was substantially overstated and far in excess of what Supreme's actual costs were. While that DCAA audit was going on, the government asserted a series of criminal and civil fraud claims against Supreme for using a subsidiary to mark up the invoice prices of certain items that were being delivered, including water. Supreme ultimately agreed in negotiations with the government to plead guilty to fraud and conspiracy against the United States, and ultimately made approximately $390 million in payments to the government in fines, forfeitures, restitution, attorney's fees, and other settlement payments. So the appeals that ultimately get filed here really fall into 3 categories as reflected on the slide. In numbers 57,884 and 61,361, DLA unilaterally established final delivery rates for the FOBs and demanded the return of $1.1 billion, which was the difference between the provisional negotiated rates and the rates that DLA unilaterally determined. On Supreme's side, in numbers 58,666 and 59,636, Supreme sought $2.4 million based on the agreed upon tentative rates. The government had not paid the agreed upon rate in that initial modification, and Supreme demanded payment according to those rates, arguing that they had been negotiated and that they were negotiated in accordance with rules and practices for commercial item contracts. And then in 59,811, in response to Supreme's claim, DLA issued a final decision declaring the void ab initio and asked the board to declare the contract void ab initio due to Supreme's guilty plea for major fraud. Let's go on to the next slide here. The most important part of this case is that the board refused to declare the contract void ab initio. The contracting officer had testified, and the board credited this testimony that she would not have signed the contract modification establishing those tentative rates had she known of the fraud that Supreme ultimately pled guilty to and reimbursed the government for. But the board held that not every fraudulent or corrupt action gives rise to a void contract, and recognized that Supreme had already made a substantial restitution and penalty payment to the government to the tune of approximately $400 million. And what was really important here is that after allegations of fraud first were raised, and after the government began to accumulate evidence of the fraud that Supreme ultimately pled guilty to, DLA repeatedly modified the contract, extended the contract, expanded the contract, and through those actions repeatedly reaffirmed the contract. A fraud by one party could give rise to a right of rescission, but that rescission remedy has to be exercised reasonably promptly. The board was sympathetic to the government's position. This was a contract for support of basic necessities for forward deployed troops in a time of war. There's a recognition within the opinion that DLA didn't have a lot of other good options, but given that Supreme did in fact deliver food to the troops, that they did what they were supposed to do, the DLA repeatedly affirmed the contract and asked them to do more. The board concluded that declaring the contract void ab initio was inappropriate. Let's go ahead to the next slide here. The board also ruled that DLA could not claw back the full $1.1 billion that it was recovering based on the rates that DLA had unilaterally established, holding that some disputed cost claims had been legitimate. And this ultimately came down to a very involved battle of the experts that should be recommended reading for anybody who wants to negotiate or litigate a cost claim on a commercial item contract. The board recognized that the government had withheld approximately $500 million in payments, but that there was a significant possibility that it would have to give some of that back to Supreme. The board did rule, based on the prior material breach doctrine, that Supreme could not claim interest because Supreme's fraud was the first material breach of the contract. So I would have thought that the resolution of the government's claim that the contract was void ab initio would also have resolved the government's position on prior material breach, that the government's repeated affirmation of the contract after the fact removed that defense. But this is an area where the board allowed the government to assert that defense in response to a claim for interest, even though it rejected the government's argument that the contract was void ab initio.
Thanks, Dan. That was a lot to chew, and I think you digested it very well. So I think we're gonna move to the next category, which is jurisdiction, and we've got 3 cases there. Again, the first one, which Judge Summers will handle, involves a way contractors can step in it. You've got an obligation for a sum certain. So Judge Summers. Oh, you're on mute. Yep. You're on mute.
Thank you. I had the microphone covered accidentally. Well, this involves 2 of my favorite things, maybe from my time at Department of Justice, jurisdictional arguments and construction. So in this case, the government awarded Odyssey a contract to construct a facility at Letterkenny Army Depot in Chambersburg, Pennsylvania. The design for the building included the use of micropiles, which was a building foundation system involving drilling small diameter holes into bedrock and inserting grout into voids in the rock before inserting metal poles and casing. The solicitation informed bidders to assume, among other things, that 2 micropiles would be installed in each pile cap, but that ultimately the contractor had to assume responsibility for the design of the micropile foundation and receive government approval of the design. Well, we know how this goes. After the contract award, the contractor raised issues about the design at the pre-construction meeting. The government says, well, prepare the design independent of the assumptions provided in the contract for bidding purposes. The design that ultimately was proposed called for more micropiles to be installed deeper into the bedrock and at a greater cost. The government asked the contractor to submit a cost proposal, which the contractor did, seeking additional cost and time. In separate emails, the contracting officer's representative and the project manager told the contractor to begin work despite the lack of an executed modification, which is always questionable. The contractor interpreted the emails as a change order and began work. Afterwards, the government canceled the proposed contract change and approved a change that would only compensate the contractor for part of the increased cost. Well, Odyssey submitted a claim with multiple legal arguments. Its consequential damages claim for damages in the amount of at least $15 million was doomed from the start for failure to state a sum certain. The rest of the decision focused consideration on whether the various theories in the complaint were the same as the claim presented. The guidance here is very simple. You always know that you want to, first of all, make sure you have an executed modification. And second, to the extent you claim damages, make sure that you put down something that is a sum certain, not at least a certain amount, because jurisdictionally you're not going to survive if there's a challenge.
Right, and this is a situation contractors face, that while if they are continuing to incur additional costs, what do you do? And it sounds like what you do is you say, I'm entitled to this amount, and then if you need to modify that later, you can do so.
Right, there's always that flexibility after you've got your claim certified and submitted, and then it's on appeal.
Right.
But here it just didn't meet that standard.
Right. Okay, and then the next case, relatively straightforward but very helpful, is Camaludin-Slyman. So, and this is the ASBCA changing its rules about whether or not it will accept as a signature on a certification a simple typed name. And I'll read you the holding before just telling you just a very little bit about this case, because the takeaway is, well, they will accept it, although you're still better off signing your certification. So here's the holding. Today we hold, so long as a mark purporting to act as a signature may be traced back to the individual making it, it counts as a signature for purposes of the CDA, whether it be signed in ink, through a digital signature application, or be a typed name. So in a letter, Camaludin had submitted a demand for payment in the amount of $155,000. And the letter alleged the government breached certain provisions of the contract. And it was, the subject line was letter of claim. Now, that letter also had a handwritten signature from Camaludin's president, but the letter didn't contain any CDA certification language. Later, Mr. Camaludin-Slyman emailed the certification, and the email cover said, "Here's the certification, sincerely, Camaludin-Slyman." And the certification itself just had his typed name. So what the board had to consider was, is this is this a valid certification? Because under the law, an unsigned, if it's not a signed certification, it's not merely defective, it's no certification at all. So the board in the case basically said, well, CDA doesn't define signature. We look at what the FAR says about signature, and the FAR says it's the discrete verifiable symbol of an individual, which when affixed to a writing with the knowledge and consent of the individual, indicates a present intention to authenticate the writing. This includes electronic symbols. So the board said in the past they had looked to two components. One is it a discrete signature, and 2, is it verifiable? And they added, well, we really need a third, which is, does the symbol indicate the present intention to authenticate the writing to which it is affixed? And here they said, look, we can see that this is the person who wrote the email. He clearly typed his name with the intent to be held responsible for this. That's good enough for us, and we're overturning other precedent on this. Now, there are a couple other judges signed a concurring opinion saying, well, we don't think we should reverse our prior precedent, but we think that this is merely a defective certification that could be cured for jurisdictional purposes. So again, the takeaway is you might be able to get away with it, but it's a lot better to sign your certifications. So the third case also could have been, and this is Seth's going to handle this for us, Mountain Movers could have also been in our fraud section, but this is a contracting officer taking some liberties to try to avoid dealing with an appeal. So Seth, you want to walk us through that?
Sure, thanks. Yeah, Mountain Movers, I mean, ultimately, the board was deciding, what jurisdiction does it have when it's faced with a claim on a contract that may involve fraud. And the key there is a claim on a contract that may involve fraud, not necessarily the claim itself. And so what happened here was Mountain Movers, Ainsworth Benning, it was a JV, a joint venture that was issued a task order to provide emergency repairing an emergency gate control system. And one of the requirements they had to provide within 10 days of award of the task order, they had to provide performance and payment bonds. And they failed to do so within those 10 days, but the government didn't take any action on it for a few months. And this is where it gets interesting. After a few months, when the government reached out and asked, well, where are your performance and payment bonds? The president of Mountain Movers, Miss Nettleton, she responded that she was having some trouble getting performance and payment bonds because the owner of Ainsworth Benning had, I think the board described it as, had split the state, had completely left the state with his family and disappeared in the middle of the night. And one of the partners of his in an Ainsworth Benning affiliate had been arrested. So things were going south for this Ainsworth Benning, and as a result, Mountain Movers was having a lot of trouble fulfilling its requirements. And what happened next was Mountain Movers got on the phone with the contracting officer for the government and just tried to work out a situation going forward. And that's where there became this dispute. And in the record, the board noted that there were conflicting declarations submitted because on the one hand, the government said, you told us certain information about which entity was actually part of the JV for Ainsworth Benning. And based on that information, we decided to pretty much issue a cure notice. Instead of, they had already issued a termination for default, we're going to walk back that termination for default. We're going to go through the cure notice process. We'll see what you can do. And the conflicting declaration by the president of Mountain Movers, according to her, she never actually said who was the entity that was going to be in the JV for Ainsworth Benning, but instead offered to find another Ainsworth Benning entity. And it gets complicated about which Ainsworth Benning entity is really at issue here. But in any case, that's not really the important part. The important part is that they were in dispute about what the facts were in order for the government to get comfortable with moving forward with Mountain Movers JV. The government ultimately did. They felt that based on the information that they believed what made up this JV, that it could go forward with the work. And Mountain Movers did. They were able to get performance and payment bonds. The government withdrew the termination for default, and Mountain Movers completed the work. And after completing the work, they submitted a claim for increased costs of about $500,000. The contracting officer at that point ended up partially granting and partially denying the claim. So they gave partial amount to Mountain Movers, and Mountain Movers appealed to the board. A few months later, after the appeal, the contracting officer said, well, he actually went back and he looked at the articles of incorporation of this JV. And it turned out all along, the bad actor, I'll say, of Ainsworth Benning was in fact the party in the JV. And you could tell from reading the decision, he felt that a fraud was committed on the government to convince the government to go forward with the work. So he quickly issued a second final decision in which he rescinded his first final decision. And he said, I do not have the authority to issue any final decision on this claim because the contract was proceeding under fraud. And the government put forth this theory at the board and trying to get the case dismissed that now that there was no final decision and that the original final decision in any case was based on fraud, the government had the ability to unilaterally rescind it and divest the board of jurisdiction over the appeal. No final decision, and the board could not decide issues based on fraud. And, ultimately the board ended up denying that. And some of the things that the government argued where it said we would not be able to avail ourselves of certain defenses and fraud-based counterclaims. Well, the board rejected that and pointed out that you can always use the affirmative defense of prior material breach. The board has the ability to make findings of material misrepresentation of fact when it holds a contract void ab initio. And the government can always separately bring a False Claims Act case in a district court and then try to stay these proceedings if in fact there's an issue of fraud. The government also made this novel argument that, well, this contractor here, Mountain Movers, they can always go to the Court of Federal Claims, and even though there's no final decision, they can do so. And the board quickly rejected that and said, you can't argue out of both sides of your mouth. You can't say that we've now rescinded the final decision and therefore there's no jurisdiction, while at the same time saying that this contractor could always go to the Court of Federal Claims. Because as the board rightly pointed out, if there is no final decision, the Court of Federal Claims also would not have jurisdiction under the CDA. So ultimately, what the board very clearly pointed out, and this is what I was getting at the beginning, is that it does not have jurisdiction over a claim involving fraud. But if a contract may involve fraud, but the claim itself that is presented to the board is not based on fraud, the board can maintain jurisdiction over that particular claim, regardless of whether the contract may involve fraud. And here, that's exactly what happened with the CO issuing a claim, or the CO issuing a final decision that had nothing to do with fraud. He didn't even know of the fraud when he issued his decision. And so at that point, the board had jurisdiction and could maintain jurisdiction regardless of what the contracting officer did after that, or unilaterally trying to pull back his final decision. So
Thanks,
I think it's.
Oh, go ahead.
I was just gonna wrap up. So I was gonna say, I think this is really important because, we see all the time where, and I think in the Supreme case that Dan was talking about earlier, we see fraud, and other cases where fraud might come up. Just when you hear the word fraud, it doesn't necessarily mean that all of a sudden the board cannot continue with an appeal or can't hear a case. But go ahead, Paul.
All right, no, thanks. I appreciate it. No, we just want to keep us on track. So we are going to move to the next area of discussion, which is elements of entitlement. And as usual, KBR has offered us some nuggets to consider, and so this is a Federal Circuit case that didn't go the contractor's way, and Robert's going to tell us a little bit about that.
Yeah, thanks, Paul. Yeah, we ought to all I guess on some days, thank KBR, and on other days, not thank them for some really great cases. This is one where KBR had a subcontractor that was providing trucks and trailers, and their contract, the prime contract, said that the government would provide adequate security for the movement of the trucks and trailers, but adequate security arguably wasn't there. The trucks and trailers stacked up at the border going into Iraq and incurred delay and disruption charges. KBR paid these costs to its subs and then submitted a claim to the government. And the government agreed to only pay the costs for storing the trailers, but not the additional costs for delays and disruptions. KBR said, we're entitled to everything because you're the one that breached the Force Protection Clause, which caused the delays at the border, but the ASPCA disagreed. They found that the government had not breached the Force Protection Clause, but more importantly for today's analysis, the board also found that KBR had not shown that the amount paid to First Kuwaiti had been reasonable. KBR had paid First Kuwaiti based on a number of assumptions, including timely performance by First Kuwaiti. In other words, there was evidence that suggested what the costs would have been and should have been for recovering, but they were assuming perfect performance by the subcontractor. And as it turns out, the records show that the subcontractor had not been performing perfectly, so those costs were overstated. The court also found that there were other holes in the evidence supporting the calculations and did not substantiate the reasonableness. And in the end, they essentially said that KBR and the subcontractor should have kept better records and found it implausible that such sophisticated companies had not kept better records. So you had raised earlier, Paul, whether concerns about the integrity of claims may seep in one way or another. We've seen quite a number of claims coming out of this region where the courts and boards have essentially said inadequate documentation. Well, whether it's truly inadequate documentation or whether there is a sense that there's questions that aren't being answered, who knows? But I think this is one case that really demonstrates if you're going to ask for a sizable amount of money, here $50 million, you really need to substantiate the costs with good records and with records that the government trusts.
Yes. Part of the problem, and you're exactly right. I mean, that's what we're talking about a war zone, and we're talking about, subcontractors who are, these subcontractors in whatever nation you happen to be in, who don't keep records the way we do, and whose business is very different. And right. I guess what I reading the case, I was just wondering if KBR had made a better effort to take into account potential poor performance by the subcontractor, or take into account that some of the delays must be on them, or take into account what facts were available that the board, that the Federal Circuit ultimately looked at and said, we're inconsistent with their approach. Might there have been a different result,
Yeah, instead of saying everything was otherwise perfect, but for your mistake in not providing adequate force protection, it's just not plausible, not credible. I think that would have helped. I think that you're right. Adequate record keeping in a war zone turns out is not so easy. And especially, I like to say to people, top 5 government contractors oftentimes don't understand the rules and don't keep adequate records. How do you expect non-US companies where English may not even be the first language to keep perfect records? And it causes, I think, these anomalies that end up in disallowances like this and not paying claims.
All right. Thanks. So next on the list is microtechnologies, and this is a scenario where a perhaps I'm trying to think of the right adjective, but creative contractor decided to put a lot of clauses into their contract that protected them in situations that ordinarily the government doesn't agree to, but ended up getting away with it. But it didn't help them in the long run. So Judge Summers, you want to talk us
Sure.
about?
And I can keep this fairly short. I know we're short on time. This one is where the Army awarded Microtech an IDIQ contract for information technology enterprise solutions. Ultimately, under this IDIQ contract, Microtech submitted a quote in response to the government's request to lease network printers, maintenance, everything else. Normally, that would just be a year-to-year contract, could be terminated, at the end of a year. But when Microtech submitted the proposal, they included the supplemental language and terms, which is something in addition to the original IDIQ contract. And these terms said that the government would not replace the product, so the printers, the network equipment, with anything functionally similar for a period of a year after termination or non-exercise of the option. So when the government notified Microtech that they decided not to exercise the option, Microtech submitted a claim for termination charges arising under the supplemental terms and conditions. The Armed Services Board, and by the way, this is a single judge decision, so non-presidential, held that these supplemental terms and conditions could not be binding on the government absent consideration. Basically, the government has a right to not exercise the option to extend the lease under FAR 52-217-9. And in addition, the judge found that the supplemental terms were unenforceable because they impose a penalty on the government that would violate the Anti-Deficiency Act, which simply was not part of the contract. So single judge, not presidential, but I think it's an interesting analysis.
Yeah. So the next case, which Judge Summers is also going to talk to us about, is another KBR case. And this involves a situation we see a lot with contractors who have contracts abroad, which is their costs, no question about it, are increased as a result, primarily as a result of the actions of other nations, not the U.S. And they're out that money, but who's gonna pay it? So Judge Summers, you want to talk to us about this KBR
Sure.
case?
Yeah, KBR, a gift that keeps on giving every single day. So in December 2012, the Navy awarded a firm fixed price contract to KBR to provide military base support on Camp Lemonnier. Camp Lemonnier is home to several thousand American military personnel hosted by the African nation of Djibouti, a country located at the Horn of Africa. KBR had previously been the base support contractor from 2002 and 2007, which becomes really important later because their proposal emphasized their understanding of the challenges of staffing, particularly with local labor brokers. And so in their proposal, they emphasized that, but they also reduced the number of host country nationals to be hired and reduced the amount of salary they plan to pay to the employees. KBR got the contract. The listener will not be surprised to hear that KBR's decision was not greeted with enthusiasm. Djibouti nationals went on strike, attacked the office of the local labor broker, and refused to work with KBR. So the Djibouti government supported the strike, and due to the strategic importance of this camp, officials at DoD and Department of State got involved and attempted to resolve the strike. Ultimately, the US government decided to obtain more funding to hire additional Djibouti nationals for the contract, and the Navy directed KBR to hire 1,037 of these nationals at the same pay rates established by the predecessor contract. And the parties modified the contract to cover the costs of these additional employees. However, KBR continued to experience problems when the country required the third-party national employees, the outside company employees, to obtain visas, which was not required under the International Defense Agreement between the US and the government. Ultimately, KBR submitted 2 certified claims for costs incurred due to the local national labor strike and to Djibouti's refusal to allow these third-party nationals into the country, as well as the newly imposed requirement for work permits and visas. KBR presented several claims, such as a third third-party beneficiary contract claim and other breach of contract claims. Its downfall here really was based on its assertions in its proposal, where it claimed to be very experienced with the challenges of working in Djibouti. In any event, ultimately, the ASBCA held that the government was not on the hook for costs incurred by KBR. Nothing in the contract put the risk of strikes and labor issues on the government. International agreements between US and Djibouti could not help KBR here, and the board rejected all of the claims. I do find one of their arguments interesting, KBR's. KBR argued that a partnership provision in the contract had obligated the government to resolve the strike, and that provision stated that the Navy wants its contractors to succeed, and the Navy intends to work to find solutions that are beneficial to both the government and to its partners. The board found that that partnership provision was merely an aspirational declaration of a desire for its success. And an attempt to find abstract solutions that would benefit all was just too amorphous to provide a binding obligation. What's more, even if the board could construe the language as imposing a clear contractual obligation, KBR failed to identify what actions the government could have taken to satisfy the obligation. Once again, the listeners should note that basic contract requirements supersede amorphous statements.
Right. Well done. So the next case that we're going to discuss, Seth's going to discuss, involves kind of an interesting situation where a government failure to provide a technical data package to its contractor as required actually created FCA liability or created an FCA suit against the contractor. For which they were seeking to recover damages. Kind of an interesting scenario. Seth, you want to take it from there?
Sure, thanks. It really is an interesting scenario, and the result here came out, I think, as it should. You know, whether or not these legal fees to defend against an FCA action should have been reimbursed as an adjustment to the contract. So what happened here was there was a contract it was actually originally to DRS to provide, DRS was supposed to create technical manuals, but in order to do so, it needed information from the original equipment manufacturer. So it needed this technical data package from the government. The government could not get the technical data package, notwithstanding the fact it was, like I said, a requirement in the contract for the contractor to comply with. But the government told the contractor, go ahead and proceed anyway. We just need this work done. And if it's going to cost more and it's going to involve more effort, that's okay. Just proceed. And so they did. And Tolliver ended up taking over the contract. It was novated over to them. And what happened was eventually 7 months after this type of performance, the government entered into a modification to the contract with Tolliver, where the government finally fixed the situation. The government removed the obligation to provide the technical data package, and it increased the firm fixed price of the contract considerably to recognize the extra work that had to be done. The problem was during that 7-month period, and based on that 7-month period, a subcontractor to Tolliver's predecessor filed an FCA action in district court saying that the contractor could not certify compliance with the performance work statement because it never had the technical data package that was required to be compliant with per the performance work statement. So he filed his FCA action in district court, and the district court dismissed. The district court said the government clearly knew that the contractor couldn't comply with that requirement, but the government told them to proceed anyway. And of course, the government did not intervene either in the case. But this relator was undeterred, and he ended up appealing that dismissal to the circuit court, to the Fourth Circuit, which also just affirmed dismissal. And at that point, Tolliver, who had, like I said, they had received novation of the contract and walked into this mess, they were out a few $100,000 in legal fees. And when they went to the government and tried to recover, and they filed a claim to recover that amount, the government said, no, it's a firm fixed price. They denied the claim. And they said, in any case, this money is not allocable to the contract. We didn't get a benefit here. And the court, and they appealed to the Court of Federal Claims. Well, the Court of Federal Claims said, wait a second, let's look at whether or not there was an equitable adjustment here. They looked at liability. For liability, they said, under the Spearin Doctrine, the government breached the implied warranty of satisfactory performance if the contractor complies with the specifications. Then it looked at causation. And it said clearly here, the government's actions were the ones that were the actual and proximate cause of this FCA suit and the costs that the contractor incurred. So the court said this is obviously necessary for an equitable adjustment, and they went ahead and granted it for the contractor. One just interesting quick tidbit at the end, under the Spearin Doctrine, under which the court found liability, it's usually, it cannot be applied with third-party claims. But what the court said here was this FCA relator, yes, a relator brought the False Claims Act, but it was in the shoes of the government. And so that FCA action really wasn't a third-party action. It was still a government action, and that's how the court was able to get around and apply the Spearin Doctrine. So very interesting, I think, fact scenario. And again, the right result for a contractor that stepped into an unfortunate situation.
Right. Not of its own making.
Oh,
So the last case that we're going to discuss in this category is one that a lot of contractors who provide data to the government, I think, are very happy about. And so this was another Federal Circuit case that I think was a real positive for federal contractors. Dan, you want to talk to us about the Boeing case?
Sure, and another Wiley Ryan success. So congratulations to you and your teams for that. This case is important. It doesn't give us the magic words to use when we mark technical data to preserve contractor rights, but it tells us we can use some words. There'll be a remand that will hopefully give us the magic words. But this is nevertheless a very important decision coming out of the Federal Circuit. The appeal involved two contracts between Boeing and the Air Force related to the F-15's electronic warfare suite. Both contracts contain the standard DFARS technical data clause, 252, 227, 7013. Both contracts, that clause required the government in both Boeing in both contracts to deliver technical data to the Air Force with unlimited rights, which meant that the government had the right to use, modify, reproduce, perform, display, release, or disclose the data in whole or in part in any manner and for any purpose whatsoever, and to have or authorize others to do so. Boeing delivered technical data to the government under those contracts, and there was no dispute that the government properly took unlimited rights in the data that Boeing delivered. As the panel explained at the outset of its opinion, and this point is really critical to the decision, notwithstanding the government's unlimited rights in the data that Boeing delivered, Boeing retained ownership of that data. And Boeing's ownership rights included the rights to control the use of that data by third parties, so long as Boeing didn't restrict the government's unlimited rights. And that's where the problems occurred. Boeing tried to apply several legends to its data deliverables that identified the rights that Boeing retained in those deliverables. The first legend stated that the data were Boeing proprietary and that third parties could use and disclose the data only as permitted in writing by Boeing or by the US government. The Air Force objected to that legend as non-conforming, arguing that since it differed from the authorized markings in the DFARS technical data clause, the deliverable should be rejected. Boeing took another shot at it, used a revised marking that expressly stated that the data was delivered to the government with unlimited rights, but stated non-US government recipients may use and disclose the data only as authorized by Boeing or the US government. Again, the Air Force rejected the deliverable, arguing that the DFARS technical data clause specified the only words that could be used to mark data delivered with unlimited rights, and that Boeing's deviation from those magic words rendered the deliverables unacceptable. The panel ultimately agreed with Boeing, ruling that the DFARS marking procedures apply only in situations when a contractor seeks to assert restrictions on the government rights, and does not address, quote, any legends that a contractor may mark on its data when it seeks to restrict only the rights of non-government third parties. So Boeing was permitted to mark its deliverables with an appropriate legend that captured Boeing's rights, the rights that Boeing retained as the owner of the data vis-a-vis third parties, so long as that legend didn't in any way restrict the government's unlimited rights. Boeing, of course, argued that its legends did not do that. The Federal Circuit, given the posture of the case on appeal, didn't feel that that issue was properly before it, required further factual development, and sent the case back down to the court in order to determine whether the markings that Boeing applied did in fact or did not in fact restrict the government's rights. So a core principle affirmed by the Federal Circuit: contractors retain ownership rights in data that's delivered with unlimited rights. Those ownership rights carry rights vis-a-vis third parties. The contractors are free to exercise so long as they don't impinge the government's unlimited rights, and contractors can mark technical data accordingly. Another kind of important aspect of this case is, now that the Federal Circuit has endorsed the use of markings to document a contractor's rights relative to third parties, it almost makes it incumbent upon contractors to do so. If contractors are going to protect their IP rights, failure to mark their deliverables accordingly could be deemed a failure to take appropriate, reasonable measures to control and preserve their ownership rights. So we need the magic words. Hopefully we'll get the magic words shortly here, but we do now know from this decision that some words are appropriate.
Thanks, Dan. Yeah, it's. I guess in the interim, people will be using the magic words or the words in the Boeing decision until further notice. Okay, we have just 10 more minutes left, or 8 more minutes left, so we're going to try to quickly move through the last category of cases, which is relatively quicker, I think. And again, we have a Boeing case, which actually Seth is going to handle for us. And again, a favorable Federal Circuit case for Boeing. So Seth, you want to tell us about that?
Sure, thanks. And like Paul said, we got back-to-back Boeing decisions. So this one involves waiver issue, went up to the Federal Circuit. Boeing had entered into a contract with the government in 2008. And, a few years after that, it had implemented accounting changes, and a dispute arose over the cost impact of those accounting changes. Boeing ended up bringing a claim in the Court of Federal Claims that alleged that the government had breached the contract by acting in a way that conflicted with the federal statute governing accounting changes. The Court of Federal Claims reviewed the situation, and one of the key aspects of this case was FAR 3606 and the way in which the cost impact of accounting changes should be determined. The Court of Federal Claims, though, didn't really get to that. They found that Boeing had waived its claim, and they found that this conflict of the government's actions versus the statute was an ambiguity that Boeing was aware of and should have raised prior to award. Could have raised it with the contracting officer, other ways, maybe a pre-award bid protest. Case went up to the Federal Circuit, and the Federal Circuit disagreed and said that there was no waiver. And the Federal Circuit pointed out that, based on this situation, Boeing did not bypass an avenue of relief because, Boeing could not bring an action pre-award of the contract. It would have been a futility to try to challenge it. For example, the contracting officer wouldn't have entertained any type of challenge. You couldn't bring a CDA challenge because the contract hadn't been entered into yet, and that would have been an issue of an administration of contract. Really no pre-award protest, because again, this was an issue of the administration of the contract and what would happen later. And then finally, you couldn't bring an APA challenge, an Administrative Procedure Act challenge, because the dispute involved cost accounting, which was exempt from review in that statute. So ultimately, as Paul said, the Federal Circuit got it right, and it's now been remanded back to the Court of Federal Claims, where the court can address Boeing's claims. So,
great. Thank you. So the next case we're going to discuss is sort of a trap for the unwary, so relatively short description here. So government issued Parsons a task order to complete a design and construct 2 facilities at McGuire Air Force Base in New Jersey. Parsons performs and then submits a claim to the Air Force seeking about $34 million in additional costs that they allegedly incurred in the design and construction process. Contracting officer issues a final decision, almost entirely denying Parsons' claim, and they appeal. So the board denies in part and sustains in part and awards Parsons about $10.5 million. But here's where it became a little dicey for Parsons. So on September 5th, 2018, the board issues 2 decisions. They had filed, one original complaint that had a bunch of different claims in it, but it files 2 decisions, one with an ASBCA number 58 something. And then for efficiency and judicial efficiency and clarity, they deal with a separate claim that they called the payroll claim as a new ASBCA number. And they issue a decision on that new number on the same day. So Parsons receives those decisions and then decides to move for reconsideration on several of the claims in the original ASBCA number, but not with respect to the payroll claim with the new ASBCA number. They get a denial of that request for reconsideration a little while later, and then within 120 days of that denial, they appeal to the Federal Circuit, both the original claims as well as the payroll claim. Well, with respect to the original claims, they're fine. Those were within 120 days of when the request for reconsideration was denied. But with respect to the new ASBCA number, they're late because the filing of a request for reconsideration with respect to the other claims did not toll the time period for appeal on the payroll claim. So, just a strange scenario that led to, a late appeal. So just a cautionary tale. And then we're gonna end with the electric boat case which Seth is going to talk to us about.
yes, thanks. And this is the last one. So what happened here is a statute of limitations issue. We had electric boat had a contract with the Navy where it had a change of law clause that allowed it to receive a price adjustment if a change in regulation or law increased its costs. Now, what's key here is the contract said, even though you have that ability for a price adjustment, it's not going to kick in until 2 years after the contract is executed. The contract was executed in 2003, August 2003. And the contract also had a provision that said if you want a price adjustment, you should follow certain documentation procedures and discussions with the government to get such price adjustment. And the contractor was also required to, quote, promptly notify the government of a change in law a situation. So what happened here was shortly after the contract was entered into, there was in fact a change in law that was a regulation for fire protection services issued by OSHA that was going to increase electric boats costs. And that was issued in September of 2004. In February 2005, Electric Boat notified the government that its costs were going to be increased because of this regulation, and notified that it was going to seek a price adjustment pursuant to the change of law clause. That was in February 2005. There then proceeded to be several years of back and forth to discuss the pricing, and Electric Boat submitted proposals seeking increased costs. The government came back and said, we think it's unsubstantiated. But eventually what happened was in May 2011, so yeah, we're talking several years, the government issued a memorandum that said, we're going to deny, we don't think you deserve these extra costs, they're unsubstantiated. But it was just a memorandum decision. And through all that time, Electric Boat, again, had just submitted informal proposals. Well, at that point in December 2012, finally Electric Boat filed their claim and the government denied it. It went to the board and the board said that it was late. It was beyond the 6-year statute of limitations. And it went up to the federal circuit and the federal circuit affirmed. And in deciding when the claim accrued, the key here was the fact that even the contract was entered into in 2003 and the change of law clause was 2004. And so the contract said that after 2 years, you can start actually getting a price adjustment for increased costs. That would have been August 2005, 2 years after the contract was entered into. They didn't submit their claim until December 2012, more than 6 years later. And what Electric Boat tried to argue was, well, there was all that back and forth, and the government did not actually deny or tell us that it wasn't going to be issuing a price adjustment until May 2011. So that's when the claim should actually start accruing. And we were just following the contract that said to document and provide information about our price adjustment. And so really the claim didn't accrue until the agency issued its memorandum denying the costs in 2011. And both the board and the federal circuit rejected that and said, no, you knew that you were on notice as of, as soon as that regulation came out, that was when you were injured. And then under the contract, 2 years from when it was executed, you could start actually seeing your injury and recover, and you had to file a claim within 6 years of that. So ultimately, once again, we see statute of limitations. Be very, very careful about when your claim accrues. And I think we are right out of time, maybe a little bit over.
Yep, thanks, Seth. So Alan, I think we covered what we needed to cover, and thanks for the opportunity.
Well, Paul, the entire panel, Judge Summers, Seth, Dan, Robert, thank you very much for squeezing an awful lot of information into a very short period of time. I'm harking back to my prior life, and I flashbacks into several amicus briefs that I filed in many of those cases. So
yeah,
on both sides, some we won, some we lost, but we are certainly up there swinging.